1,000 cases risk collapse in evidence war. The fight to stop investigators from secretly searching Graft suspect bank accounts and premises move to the Supreme Court. So I remember this very well, Sam. Actually, at the beginning of this year, there was a push from members of parliament saying that they want to make sure that when it comes to Graft cases, that their bank's accounts are also not part of, should I say, quote unquote, the search part of the investigation, which raises a lot of questions. How are you going to conduct searching Graft, more so investigations where it has to do with economic crime and you can access someone's bank account? So a lot of issues around that. But take a look at what a few other people say. The faces right there, Evans Kidero, the former Nairobi governor who is facing charges of alleged loss of 213 million Kenyan shillings, says his bank statements were illegally obtained. Ferdinand Waititu, prosecution has accused the Kiambu governor of pocketing 52 million Kenyan shillings in bribes from 588 million road project. It goes on. We also have Moses Lenokulal, who is also battling charges in courts, and of course Jimmy Kiamba, who is the former Nairobi County CFO, who has been ordered for forfeit of 318 million Kenyan shillings to the state, but argues that investigators raided his bank accounts without him knowing.
And I think we can begin with that conversation because, I mean, it's a never-ending when it comes to the fight against graft. So many efforts being made, but of course you can see how the Defense Council will be arguing in court. And I don't know, Gladys Boshele, how does this sit in now that the court has said that the secret search warrants during investigations are illegal? How then do you approach these cases, especially those that's already in court?
You know, I think we all support the fight against corruption, but again, we cannot do it at the expense of, one, the right to privacy, two, the presumption of innocence, and also the protection so that you have fair administrative action. So I think there has to be a clear balance about this, and I'm glad that it's coming before the courts and it's going to the, so that at least people can begin to have a conversation about it. Because when you say that I can secretly search your bank account without following due process, you can decide, the Anti-Corruption Authority can decide they're going to search my bank account, but not search Honorable Millie's bank account. So it can go to selective prosecution. That's very dangerous. And once we start going on that slope, it's a slippery slope.
Is it
on the right to privacy? Again, we must protect that. There has to be a balance. And that is why it's required that usually to get that kind of search warrant, that's why it makes sense that one goes to ask for it from the court, then the court gives the order, and then it can be permitted. It gives the other person a chance at least to go through due process and try and defend themselves, because it can become dangerous. You may think it's okay now because we are fighting graft, but one time it can be used against you in an unfair manner.
Nevertheless, is it realistic for us to have graft cases, more so the ones that are based on economic crime, and us suggesting that we cannot have the DPP and DCI cannot secretly search graft suspected bank accounts? No, is that realistic?
No. It is, but I'm not saying that you shouldn't search it. We're just saying that you've got to go to the court and get a court order to be allowed to do that, or you can demand from the person. Remember, they're allowed to undertake a lifestyle audit. So use due process. Do it, but use due process. Don't do it secretly without the person or the owner of the account knowing.
But how effective can that be? So that, I mean, if you tell me that you're searching my accounts, I can do some fishy things to ensure that I am able to hide a few things, in as much as you'll be in a position to look at the trail. You can't delete
bank records.
In as much as you'll be in a position to look at the trail. Isn't it self-defeating that you inform people this is what we are going to do? How do you balance the right to privacy as well as the interest of justice?
I think this is one of these interesting situations that we find ourselves in as a country. I come from a human rights background, and as a human rights practitioner, I'm very concerned about due process issues. But at the same time, we want to deal with the issue of corruption. Now, if you look at the genesis of the human rights chapter in the Bill of Rights, especially of the Constitution, one of the thoughts around it was not paying due attention to technicalities when we are looking at certain rights. And that therefore means that And I'd really love to see how the Supreme Court looks at it, because it's gone to the Supreme Court. But I think we may have reached a point as a country, especially in dealing with corruption, that we may have to pay less attention to technicalities. And for me, it's yes, as Gladys says, it's a delicate balance, because we'll be talking about the right to privacy, but then at the same time, we'll be balancing the right to privacy as against the right to life of the people who probably are denied the opportunity, in case these persons are found guilty of life-saving medicines, which these monies could have gone to. But then again, you have to balance it against the being presumed innocent. And I think, just as I've said, I think it's one of those things I would love to see how the Supreme Court wiggles out of, because we must look at dealing decisively with corruption. And I'm thinking about it as Millie Odhiambo, and I'm like, how would it affect me if my account is accessed privately? Honestly, I don't care, because I have nothing to hide.
Right.
Yeah, I don't care. You probably will find that you might actually accuse me of having too little money as a leader, but I don't care if you search my account privately. So really, if you have nothing to hide, why are you scared? Because sometimes there are certain rights that must go above those due process. There are no times that we do away with due process, but we must balance.
And Gladwell, so how effective would the investigations be, and even prosecution, if you are to lift the covert sort of investigations into these issues? How do you get out of that, bearing in mind the contextual reality we have in Kenya?
Actually, I want to refer to the matter that is being investigated now, the Mara University issue. I'm assuming if we were to alert the leaders there, that actually some investigation is going to be done. There's a lot would have lost. And like any other investigation process, how is it done? I think the corruption investigations which are being done are more even criminal than any other. It's a financial crime, economic crime. And so for me, I would, like Millie is saying, as much as we want to keep people's privacy, it cannot defeat the fact that we need to get justice for Kenyans who are lacking services because of few individuals who are looting money without actually caring. So for me, if the issue has gone to Supreme Court, then we need to have clear procedures that people are aware of, so that when you are being investigated, you will no longer put it like it is illegal. So for me, investigations, whichever matter, even for killings, you are not going to be told that now we are going to investigate you in this manner and the other manner. So when it comes to corruption, I don't think we don't need to be so keen on privacy, other than somebody having actually finished it.
But you don't see we risk, like she says, selective investigation and prosecution? And
that's why we are saying, if the matter has gone to Supreme Court, then those are some of the issues which they need to consider. And that leads me to my next question, Honorable Shirley. The fact that this is at the Supreme Court, does the Supreme Court have powers to listen to this appeal, given that this is not anything that is of public interest?
No, I think that's why we have a Supreme Court. The law is one thing. The interpretation of the law is something else. So what people are going to the Supreme Court for is the interpretation on the law. And obviously, because the law does not detail everything, like I said, we need to have a balance between all these rights. Yes, we need to fight corruption, but there is also the right to privacy, but there is also the presumption of innocence. So how do we, a fair administrative action, how do we deal with that? The Supreme Court can then come up with guidelines on how to balance all those rights while still being able to fight the war on corruption. So that is why it's important sometimes, and I'm happy that it's going to the Supreme Court, because we will then have a well-reasoned, because the Supreme Court will create like some sort of rules on how to go about.
So you don't think these 1,000 cases on graft collapsing? You don't see them collapsing?
I don't see them collapsing, because if you've collected all other evidence and then the only failing that you made was that you undertook secret searches, I don't think the entire cases were based on secret searches.
Right.
I believe that there was other triggers or other evidence that caused them to go and undertake the secret searches. So I don't believe if they are going to collapse because of just that, then I'm very worried about the investigators. They're doing a bad job.